Can I begin by welcoming everyone tonight to Quadrant Chamber's annual Energy Disputes event for 2018. The format of tonight's event is going to be 4 presentations, 2 from members of Chambers and 2 from highly regarded invited panellists. Each presentation will be about 15 minutes and there will be time for questions to the speakers after the presentations. And I hope you will make use of that opportunity. It's customary for the chair to end the session with a vote of thanks to the speakers and the organisers. But can I begin with an early thank you from myself and from the other members of Quadrant Chambers. And can we thank David and his partners at Clyde & Co for their hospitality in allowing us to hold tonight's event here. Thank you very much, ladies and gentlemen. I now hand over to our first speaker, Mr. Simon Rainey.
My topic is about things falling apart in the North Sea, which seems to be happening on a regular basis, and how force majeure clauses in the oil and gas industry work in that context. It's surprising that the North Sea oil field and oil and gas field is 50 years old. The first gas coming off in 1967 and the first oil in 1975. Googling a mature basin on Google, this came up in The Economist. The structural crisis is one of old age. The North Sea basin is now termed ultra-mature. Not many of us want to put our hands up for that. Others less politely liken it to a maritime used car lot with second-hand rigs changing hands at low prices and old bangers being decommissioned or turned into scrap. James Turner is going to be talking about the old bangers in just a moment. I want to talk about a particular incident and consider how it plays out in standard force majeure clauses in the oil and gas industry. And the incident I take as my example is the closure of the Forties field by INEOS in December 2017. You recall that Mr. Ratcliffe, now heading the Times Rich List, and his company INEOS took over the BP Forties field in the autumn of 2017. Luckily, he took it over so recently before the collapse of the field that when the journalists came to take photographs of the terrible things that were happening due to force majeure, BP's sign was still outside. Nevertheless, it looked very bad for INEOS, having to call force majeure on the Forties field with widespread oil and gas pipeline closures. Very dramatic photograph here from the Times. It's just steam at night. But in fact, the actual incident was much less dramatic. Here is a picture of what went wrong. This is the pipe in a field in Scotland, which experienced a crack. There's the little hole that had to be dug to deal with it. Here is the knock-on effect that it had. If you think of the little lines down like tube lines running out from the Kinneil terminal, the crack was in one of those and the whole of the Forties field had to be closed. So all of that was shut. The effect on the oil price was dramatic. It pushed Brent above $65 the first time since 2015, and there was major disruption. As if INEOS weren't out of the wood yet, when that is over, they just had a recent further force majeure declaration, luckily of shorter interval. So how does it work in terms of force majeure and force majeure clauses in the industry? A typical set of characteristics of a force majeure provision in the oil and gas industry really can be boiled down, I think, to 4. First of all, you've got your usual general circumstances beyond the control of any party, and I'll come on to that because that I think is quite a difficult area. Secondly, you've got the usual list of things which are automatically force majeure, cyclones, tempests, things like that. Unusually, and typically for the oil and gas industry, you will then have, commonly, I put it in square brackets because it's not invariable, a carve-out for specific excluded clauses which are not to be treated as force majeure and are allocated off as risk to one or other party. And then, like all force majeure clauses, there's a requirement to claim force majeure coupled with notice and supporting documents requirements. I think 3 issues arise, and one can test the INEOS case against these 3 issues. The first question is the event covered by one of the specific enumerated causes of force majeure, or does it fall within one of the excluded causes? If you don't get an answer to that question, the second issue is is it caught by the general beyond the party's control provision for force majeure, the sweeper? Thirdly, have you claimed force majeure in the manner prescribed by the contract, and if you haven't, what are the consequences of doing so? And in the 15 minutes which have been allocated to me, I will take those issues quite quickly. First issue then is the force majeure issue which you are claiming within force majeure event at all? And that requires you to look very closely at the terms of the contract which you're using. It's particularly apposite if there's an exclusion of causes in addition to the enumeration of causes, because you'll be asking yourself, is it within the excluded list of causes? If it's not, is it within the list of agreed causes? And even if it is within the list of agreed causes, does it satisfy the requisite causative link? Because you have to be prevented or hindered, or whatever the relevant phrase is, by the force majeure event. And in the oil and gas industry, an important factor is the standard of obligation of the reasonable prudent operator. And I'll come back to that in relation to certain types of force majeure provision. Exclusions which are relevant to ageing infrastructure issues compare and contrast two different forms. Can I have my water, please? The first comes from a long-term SPA for LNG. The second comes from the agreement for the use of the CATS North Sea pipeline. As you'll see, they cover breakdown or failure of equipment caused by normal wear and tear, which is pretty much of a problem if you're looking at ageing infrastructure in a mature basin. The more elaborate clause deals with breakdown or failure of machinery caused by normal wear and tear, which should have been avoided by a reasonable and prudent operator, and, for example, non-availability of equipment or spare parts, where a reasonable, prudent operator would have had those available. So that poses the first real issue. The second issue is if you don't find your answer in the specifically enumerated causes or the specifically excluded causes, then you have to go back to the sweeper, which is beyond my control. You'll remember this film, Les Liaisons Dangereuses, where the Marquis de Valmont cruelly rebuffed Madame de Tourvel's pleas for love, constantly saying, it's beyond my control, it's beyond my control. Unfortunately, this part of the talk, that's the most exciting bit you're going to get. I take two typical sale clauses. And the reason I'm taking these two will become apparent in a minute. Here are the total terms, and they say that neither party should be deemed in breach of the agreement for any cause reasonably beyond or to be treated as reasonably beyond the control of that party. And at the bottom there are the NNPC terms, which again say, but this time in terms of neither the seller nor the buyer shall be held liable by the occurrence of an unforeseen act or event, or which is beyond the reasonable control of either party. Now, who do we mean by party? Whose control does it really have to be beyond? Think of INEOS and INEOS using contractors to do various bits of work on the North Sea. Within whose control is the relevant event? And this came up in a particular case involving the oil and gas industry, involving this padlock. This is the actual padlock. This is the replacement padlock, which secured the main export line for the ACPO FPSO in Nigeria. And how it came up was this. It's a case called the Crude Sky, in which I acted for one of the middle parties. There was a long string of sales of this Nigerian crude ACPO condensate, from Total at one end, who were the actual terminal operators and exporters, to Trafigura at the other. And it went through various companies. I was acting for COOSI, through various VTOL entities, and then up to Trafigura. The vessel arrived. One man has the key to the padlock from the Department of Petroleum Resources. He pushes off and no one knows where he's gone. Lots of tankers lining up, and so Total ring the DPR at Port Harcourt and say, your chap's gone, can we cut the padlock? They say, by all means, go ahead. Loading commences. A man comes from the DPR the next morning and says, what the hell have you been doing? You've cut the padlock. This is a dastardly act, and that was the official term. You're in breach of criminal law, never identified, and a $20 million fine was slapped, and the vessel waited for 6 months. COSI, my clients, and VTOL and Trafigura all sought to rely upon force majeure, effectively saying, well, these circumstances are entirely beyond our control. Total did it, but we had no involvement, they didn't ask us, it's nothing to do with us at all. And the question is, how does a force majeure provision apply in that sort of circumstance? Does it excuse the party for acts which are actually beyond its own personal control? Or if not, and it goes wider, how much wider and why? The authorities before the crude sky, there were two cases, decided within 3 weeks of each other, and the later one didn't refer to the earlier one because it wasn't cited. And they come to completely different conclusions. The two cases, the Marine Star and the Critti Rex. In the Marine Star, it's absolutely similar string context. The force majeure clause referred to circumstances directly or indirectly resulting from any cause beyond seller's or buyer's control. So you'd think, well, that looks at the seller or the buyer, personal to him. And the Court of Appeal endorsed that and said, it seems to me that as a matter of construction, the word seller or buyer, here seller or sellers, means and can only mean the selling party in the relevant contract and not anybody else further up or further down the chain. So far so good. You can imagine that I relied upon that case a lot. But there's another case, the Critti Rex, where Mr Justice Moorbeck, in relation to a clause which referred to other events beyond the control of the parties, said that you construe such clauses according to their language, which means events which arise without the fault of either party and for which neither of them has undertaken responsibility. So not just looking at the party, but the things that the person has accepted responsibility for. And that was applied in the crude sky. In the crude sky, the court had to construe two types of force majeure provision. First of all, the NNPC terms. And remember, they said either party. And the question was, were Total's activities within Vitol's control? Vitol was about 4 up in the string, miles away from Total. And the Court of Appeal said, yes, it does cover Total's activities because the force majeure clause means beyond the reasonable control of that party, that's the language, or any party to whom contractual performance of that party's obligation has been delegated by that party. And the court recognised that as a matter of construction, that's a pretty controversial view to that party. It got worse. My clients had to rely upon the Total terms. We thought we had a good point over on Vitol because the Total terms are much more sophisticated. They define party as being the particular seller and the particular buyer. They have a long set of definitions which say this shall not include the loading terminal, which is a separate party, and various other parties. So we said, well, as a matter of construction, that party will only mean us and does not apply more widely. That got nowhere, and the Court of Appeal said there was really no distinction, and COSI was just as liable because it can't show that the relevant acts and events were beyond the reasonable control of Total, being the person who discharged the responsibility. And there's a case that's going to come up for trial in July, in which I'm involved, where this argument has been relied upon in relation to the Samarco dam collapse. And this again is highly relevant for the INEOS type scenario when something goes terribly wrong due to aging infrastructure. This is the picture of the aftermath of the Samarco tailings dam, which collapsed suddenly one night, flooding a valley and closing the whole of the iron ore crude production from Samarco and killing many people. The clause in that case refers to act of God, floods, landslips, accidents at mine or production facility, or any other causes beyond the owner's, charter, shipper's or receiver's control. And Classic, I'm acting for Lion Holdings, Classic intend to argue that the dam burst was due to faulty engineering by Samarco, because Samarco are effectively supplying the cargo which I'm supplying under the contract. Samarco is my delegate, and therefore the person for whom I'm responsible under the crude sky, and in those circumstances I can't rely upon the force majeure clause, which seems a pretty extreme result. And we will submit, if anybody's here from the solicitors on the other side, fails to recognise the proper understanding of the delegate principle of the global Santosh. But how does that work in an oil and gas context? Take a typical force majeure clause which deals with the RPO, the reasonable prudent operator. I've set out the provisions here, and I can feel Nigel twitching, so I won't read them out to you. But let me break them down. Usually you have a force majeure clause that says any event or circumstances which is beyond the control of the person affected acting as an RPO. And then there's a definition of the RPO. And I've set both of those out in full. Let's just take the force majeure provision and break it down. Any event or circumstance which is beyond the control of the person affected. Well, does that exclude the crude sky principle? Probably not. But that goes on to say, acting or having acted as a reasonable and prudent operator. Now that's looking at that person doing a particular thing and acting in a particular way. Nothing very personal to that person. Resulting in or causing the failure by the person affected to perform any more or more of its obligations under the relevant agreement. So I think there's a very respectable argument there that under that type of force majeure provision, the crude sky principle is excluded as a matter of construction. And when one considers the definition of RPO, with which that has to be read, that is very, very personal to the operator. A person seeking in good faith to perform its contractual obligations and in so doing and in the general conduct of its undertaking, exercising that degree of skill, diligence, prudence and foresight which would reasonably and ordinarily be expected. So I would suggest that the crude sky does not apply in that particular situation. So that sort of clause probably, I say optimistically, says farewell to the crude sky argument. But does it bring you back to other arguments being run in classic maritime and Lion Holdings, which comes on for trial next July? I can refer to this case because they applied for summary judgment against us and lost, and so it is a reported case and these arguments are all out there. Optional modes of performance. Classic want to argue that because there was an option under the contract, we could ship either from Samarco's terminal or Vale's terminal or both. Because we chose to ship, for historic reasons, always from Samarco's terminal, when Samarco's terminal was shut down, it was all our fault that we couldn't perform the contract, because we should always have had in place a plan B with a backup contract with Vale. That seems to me to be legally ridiculous. But if you consider the RPO obligations and think of an aging field, an RPO is going to have to consider redundancy in systems that are starting to get old, backup for mature or aging systems, special foresight for potential wear out, different inspection and verification procedures. So I foresee the battleground on these force majeure provisions, and I've got one case on at the moment where this argument is coming up, as being on, well, you should have anticipated as an RPO that these things are getting older and you should have done something more about it. My last issue is valid notification and requirements for claiming force majeure. You will recall in the Scottish Power and BP exploration case, which dealt with force majeure, where I think there was valid force majeure for 11 days. BP then sought to shut down the field for another 2.5 years to allow shutdown to do a splice in for another field and said, well, all that's force majeure. That argument had to be dropped before trial. But there's some interesting bits in the case on the notice provisions. Very often one has notice provisions which are being relied upon as condition precedents. Oh, they didn't claim notice. They didn't give notice of force majeure within 12 days. That's it. They can't claim it. I think that the current dynamic now is that's not going to work unless it actually says it is a condition precedent. And the second question is, can one convert the serious breach of the obligation to notify into one so serious that one cannot rely on force majeure? Effectively, it was said that because you were 3 days late in notifying force majeure and because you didn't give us the supporting documentation, that's such a breach of the obligation that you're not entitled to rely upon force majeure. A novel argument, and one that Mr. Justice Leggett found to be legally nonsensical. So I leave you with the Christmas card that INEOS didn't send. Here is a picture of the same site, looking very, very pretty in the late December sunshine, covered in snow, and you will notice there are no men working. Thank you very much indeed.
Good evening. Let's start with something of an apology, because although the title of my talk is Decommissioning Disputes, actually I'm going to talk mostly about decommissioning and its legal framework. But you can judge me for that later on. Now this, in case you didn't know, is the pioneering spirit. She's a useful jumping off point for a number of decommissioning themes. Picking just three, the first of them is scale. Decommissioning projects can be eye-watering in scale. There are very few companies, if any, that have the full spectrum of resources available in-house, and I'll come back to that. But while on the subject of scale, it's worth considering just the North Sea as a whole. From 2017, so last year, to 2025, decommissioning is forecast to take place on 349 fields. 200 platforms are forecast for complete or partial removal. Nearly 2,500 wells are to be plugged and abandoned, and nearly 7,800 kilometres of pipeline are forecast to be decommissioned. And all of that is forecast to cost about 17 billion pounds. The second is planning and duration. Now, decommissioning is drawn out. It took the pioneering Spirit just 12 hours to lift the Brent Delta platform off its legs, but actually doing the work is stage 4 in a 5-step process that I'll come back to, a process that can start a decade earlier and last for the rest of time. And thirdly, publicity. Decommissioning is public. Take the pioneering Spirit. As you probably know, she was christened the Peter Schelte. There you go, David, I've worked in some Dutch. After the pioneering offshore specialist Peter Schelte Hirama. Unfortunately, he was also an ex-member of the Waffen-SS, although he is said to have recanted and changed sides in 1943. When she turned up in Rotterdam a few days before the 70th anniversary of the liberation of Auschwitz, the resulting outrage, nowadays we would call it a Twitter storm, led to a change of name. Now, Allseas is taking no chances with the following vessel. She is to be christened the Amazing Grace. Another theme that decommissioning gives birth to is that it takes place within tightly controlled regulatory framework. So I'm going to give a quick refresher on the framework applying on the UK continental shelf off England. And that's a cop-out because the waters off Scotland bring their own regulatory layer on top. For present purposes, let's start with UNCLOS. The United Nations Law of the Sea 1982 entered force in 1994 and the UK signed up to it in 1997. And Article 60 sub 3 makes express provision for the removal of abandoned and disused structures. UNCLOS was effectively replaced, as far as the UK continental shelf is concerned, by OSPAR, the Convention on the Protection of the Marine Environment of the North East Atlantic 1992. And if anyone can explain to me how you get OSPAR out of that, I should love to know. In late 1995, most of us will recall, Greenpeace activists landed on the Brent Spar to try and stop Shell dumping it at sea. They succeeded in generating huge public and international outcry. And although the UK government stood firm, Shell eventually backed down, and eventually, after a lot of drawn-out consultation, and indeed in some ways Shell set the template for what has become the regulatory regime with the consultation exercise that they carried out after they had parked the Brent Spar in a fjord, they backed down and changed their plans to onshore disposal, although part of the column was chopped up into slices and used as a jetty in a port in Norway. Now, decision 95-1 was reached in August 1995, so in the course of the Brent Spar saga, and a majority of the OSPAR nations, with only the UK and Norway voting against, adopted the decision, which was a moratorium on the dumping of offshore installations at sea. After the Brent Spar consultation exercise and some diplomacy, in July 1998, the first ministerial meeting of the OSPAR Commission adopted a binding decision, Decision 98-3, banning the disposal of offshore installations at sea, whilst permitting national regulators to grant derogations in some circumstances. And Decision 98-3 is the international legal underpinning of the regime which governs offshore decommissioning, which in the UK is the Petroleum Act 1998. Under the 1998 Act, decommissioning in the UK is regulated principally by the Offshore Petroleum Regulator for the Environment and Decommissioning, OPRED for short. OPRED is part of a directorate within the Department for Business, Enterprise and Industrial Strategy. The 98 Act was amended by the Energy Acts 2008 and 2016, and the latter established the OGA, which you can probably just see above the transom of the rib there. The Oil and Gas Authority is another independent regulator, although awkwardly perhaps wholly owned by the Secretary of State for Business, Enterprise and so on. Its role is to regulate, influence and promote the UK oil and gas industry. And its task is to maximise the economic recovery of oil and gas, which is why you may see MER UK as a collection of acronyms associated with this. And their task is also to maintain strategic oversight on the UK continental shelf infrastructure. So in the context of decommissioning, it acts principally as a brake on activity. Production cannot cease and decommissioning cannot start without OGA approval. And then there are some other regulators, and they include the Health and Safety Executive in their role as the Offshore Safety Directive Regulator under the EU Directive 2013-30 and various other statutory instruments that I will spare you. The Environment Agency, which is responsible for administering and enforcing waste management control. DEFRA, which is the principal government coordinator of policy on the marine environment and leads for the UK under OSPAR and another associated convention. The MCA, pretty obviously, various conservation bodies, the MOD and the UK Hydrographic Office. If you need a notice to mariners because you're doing work around an installation, then the operator will have to pay for it. There's even an MOD Directorate of Safety, Environment and Fire Policy if your decommissioning is interfering with defence activities. The Customs and Treasury, they always want something, and the Crown Estate, which is vested with all the rights to oil and gas under the territorial sea and the UK continental shelf. Their interests are managed by the OGA, but you may have to liaise with both. So much for the regulators for now. Let's think about the objects of decommissioning. That is actually a decommissioning vessel. Firstly, well plugging and abandonment. About half of the forecast decommissioning expenditure to 2025 is expected to go on P&A activities. P&A may be conducted in one go or in phases, some of which may be done with or without a rig. And in shallower waters, one can expect to see jackups being used, which is nice because they've just started scrapping jackups. Topsides, the platform part of a platform, and they come apart in three ways. Piece small, which is chopping it up using onshore demolition techniques. Piece large, which is removing the modules of a modular rig. And single lift, which is what we all saw last year with the Brent Delta platform. And if you haven't seen it, then go to the Allseas website or YouTube and look it up because it is a seriously impressive piece of engineering. But basically they took off the entire topside in a single lift, took it away from the legs, and then took it closer inshore, put it on a barge, and it then ran off rails from the barge onto rails on the shore. Very slick. There is the platform substructure. Now the removal method and the extent of the removal will depend on the type, weight and configuration of the substructure. There is scope for derogation from decision 1983 here with very heavy substructures, those weighing over 10,000 tonnes, possibly being left in place. But if you leave them in place, obviously you've got to mark them and to navigation and monitor them forever. I'll come back to that. There's the subsea infrastructure, so you've got to get rid of your manifolds, Christmas trees, riser spools, jumpers, anchors, isolation valves. About 54,000 tonnes of kit across the North Sea is scheduled to be moved in the period to 2025. Cuttings. Drill cuttings typically accumulate under platforms, and whether, and if so, how they are to be removed is a matter for negotiation with the regulator. Pipelines. Now, pipelines don't fall under the OSPAR decision 98.3, but they are regulated in a similar way under the 98 Act, and they can be fully removed, decommissioned in situ, or trenched or buried. But whatever happens to them, particularly the last two, they'll have to be cleaned properly first. Mattresses also have to be removed unless they're too badly degraded. Across the UK, Norwegian and Danish continental shelves, there are about 15,200 mattresses forecast for decommissioning in the period to 2025. Now, quickly on the process itself, I've already mentioned that decommissioning is a 5-stage process, and that's the official position, but in reality it's a 6-stage process. The first stage involves the operator itself working out how best to carry out the decommissioning in question, and that can take a long time. Shell's investigations into decommissioning Brent started about a decade before the actual work. And so this stage will overlap with the official stage 1, which is initial discussion with OPRED. And that discussion is supposed to start up to 3 years in advance of cessation of production, COP. But if you're going to seek a derogation, then that's 5 years in advance, so very long lead times. And bear in mind that you've got to have OGA approval before you get to cessation of production and start decommissioning. You can see that your timelines are quite tentative that far out. There's then a consultation phase, and that's a drawn-out phase in which the draft decommissioning program is produced and then kicked around by just about everybody, including OPRED itself, government departments and agencies, statutory consultees, the public, which means environmental agencies as well. And if you are seeking derogation, then you will also have to submit a derogation document. At the end of that, OPRED asks for the program to be submitted. By that stage, it's in a pretty much agreed form. It is submitted and then approved by the Secretary of State. Then the decommissioning work itself can be undertaken in accordance with the program. Now, all of this is necessary because if you just go and decommission, then you're committing a criminal offence, which is on the whole a bad thing. And then after that's done, stage 5, monitoring. The operator will have to carry out post-commissioning monitoring, possibly in perpetuity, as specified in the program. It'll be submitting reports to OPRED, and OPRED will be reporting on to OSPAR. So, disputes. Now, some decommissioning work will be carried out in fairly close proximity to platforms and wells which are still producing and pipelines which are still carrying hydrocarbons. And lawyers tend to start salivating when they see the potential for serious damage and disruption that all of that involves. But in reality, that potential is minimized by the very extensive planning, preparation and engineering that goes into these projects. And the real potential for disputes it lies in more anodyne areas. The first of them, I think, is judicial review. In an environment as tightly regulated, as public and as politicized as this, there is scope for challenge to administrative decisions, both by operators and by interested third parties. And it's worth noting that it's not just in approving plans. The Secretary of State has power under the 98 Act to impose decommissioning liability on a surprisingly wide range of existing, former and even future owners, operators and associated companies. And you must bear in mind that we're not just talking about the offshore element. There are onshore planning restrictions and approvals in relation to dismantling, recycling and waste disposal. There's tax. One of the financial challenges for operators is that decommissioning is expensive and by definition carried out when the well, platform or equipment is no longer profitable. And that can make it difficult to set the costs off against tax. And precisely that consideration led to an attempt by Marathon Oil to claim a special allowance for capital expenditure by paying $300 million to a subsidiary it had set up for decommissioning and claiming that there was a capital expense before it was actually spending anything on decommissioning. Well, it was a nice try, but in front of the first tier tribunal last year, that attempt failed. But the position is now mitigated somewhat by what are called decommissioning relief deeds provided for in the Finance Act 2013. And contractual disputes, closer to my own heart. There are 3 principal areas here, I think. The first is in the advanced work, the project management, the engineering, the risk assessment. They all have the potential to get it wrong. Whether disputes actually result will depend on the extent to which work is outsourced, and if it is on the contractual terms and on the pockets of the consultancies doing the work. The contracts themselves, we will see VOR, and I have seen VOR disputes, delay disputes, performance disputes, hire and off-hire and so on. And we can expect particular scrutiny and stress testing of contractual division of risks regarding delay and damage and of the mechanisms to address additions to work scope. And joint ventures. As I mentioned at the beginning of this talk, decommissioning projects can be huge, and there are few, if any, one-stop shops that can handle all aspects of the process. But most operators will want to keep the number of contracts they have to manage to a minimum. So if you've got that dynamic and a number of smaller companies all wanting to get involved, which have relevant but not all expertise, there is obvious market pressure for JVs to form. And you will have seen in the press that only last month Maersk announced a JV between Maersk Drilling and Maersk Supply Services for decommissioning activities. Now, JV contracts can be, in my experience at least, less structured and not to have covered all the bases as well as, for example, a standard form BIMCO contract. And it makes them a potentially fertile source of disputes, and I've certainly seen that in my own work. In a similar vein, disputes can arise under existing JOAs, particularly where one party wants to decommission and another doesn't. Now, those are unlikely to make it to court or arbitration for all sorts of reasons, not the least of which is that most JOAs nowadays express provision for decommissioning, and they will be accompanied by decommissioning security agreements. But that may not be the case with some older JOAs. Finally, decommissioning has been going on in the North Sea for about 30 years since Brent Alpha was toppled off its legs. And the expectation, or was it Piper Alpha? And the expectation is that activity and expenditure is going to pick up over the next few years. As matters stand, vanishingly few disputes have got as far as court. Now that'll be because of arbitration clauses, commercial imperatives, and the extent of planning. But as the pace picks up and expectations rise, who knows? Thank you for your attention.
Thank you very much, James, and good evening, ladies and gentlemen. May I, on behalf of all of us at Clyde & Co, wish you a very warm welcome here tonight. It's great to see so many of you here. Please do stay for a drink. We've got some very strong drink next door, which I think you may need after the session. I'd also like to thank Quadrant and particularly Sarah for putting this event on. They've done a fantastic job, and it's a brilliant seminar, so thank you very, very much for putting it on. It falls to me at this juncture in the evening, I'm afraid, to lower the tone quite significantly from the exalted, rarefied heights of the purity of these two QCs. I'm afraid I'm going to descend into the depths of dreadful, dastardly actions, namely bribery and corruption. And when I say bribery and corruption, I should really say alleged bribery and corruption, because every single one of you in this room, including your clients, and indeed Quadrant barristers, and indeed Quadrant clerks, are innocent until proven guilty. Now, this is something that the regulators seem to have forgotten, and the police and the media. And I'll come back to that shortly, but we do have to remember that these are allegations, but a lot of damage is done before you get anywhere near a trial in these cases. So the oil industry is obviously in a very challenging environment. The other reason I think why it's such a huge issue for the sector is the contracting structure. James mentioned a minute ago that JVs and JOAs are ripe for dispute. They're ripe for all sorts of problems, contractually and otherwise. And they're also ripe for difficulties when it comes to controlling the people in the contractual chain. But the bottom line is that if you are operating in this sector and you are involved in JOAs in places that show up on the chart that I showed you a minute ago, the red places, then you are at real risk of inadvertently getting caught up in someone else's bribery. It might have had very, very little to do with you, but if you're a member of a JOA, you could get caught out, and people are getting caught out, and we're involved in one at the moment where we're arguing about this. So the oil industry is very much rife for this sort of situation. So I wanted to just, in the 10 minutes or so that remain, just give you a very brief snapshot of where we are today in bribery and corruption. I'm obviously not going to have time to go through the law itself. But in order to do that, I thought we would take a little trip down memory lane and ask the question, where were we before? And the date I've taken is 1990. And just to cheer you up, that's a little picture of Margaret Thatcher and the clean-faced Robert Mugabe, who in those days was a hero, funnily enough. But back in 1990, if we take a snapshot of where we were in the regulatory regime at that time, bribery and corruption didn't really exist. It wasn't on the radar at all. And there were virtually no prosecutions for it, not only in this country, but elsewhere. Even when we had catastrophic situations such as the Piper Alpha disaster, which obviously Lord Cullen's report came out in 1990. I appreciate a lot of you in this room weren't even born then. But the Cullen report was interesting because 104 recommendations of gross negligence. Not a single company was prosecuted in the criminal courts after Piper Alpha, and the civil litigation was really very minimal. If you fast forward to the more recent Macondo incident, of course, it's a completely different landscape 20, 30 years down the line, with BP paying out something in the region of $60 billion in relation to various litigation, including criminal litigation. So the landscape and the regulatory regime has changed enormously, and we can see this from the statistics from our friends over the Atlantic. The increase in cases in the last 10 years or so has been absolutely incredible. And guess what? The reason for that is the fines and penalties and that wonderful expression, disgorgement of profits, has been going through the roof. And guess where that money goes? Into the Treasury in this country, and we'll come back to that in a minute. So we are seeing in this country a significant increase in the fines and penalties that are being imposed, and the amount of activity by the SFO, which we'll come on to in a minute. So obviously we've got the Bribery Act, but there's a lot of change at the SFO. And what they are saying, following the US model, which is essentially get these huge fines and disgorgements of profits out of defendants. Their budget, £53 million. They're returned to the Treasury in fines and confiscations in the same year over £500 million. That is the way forward, I'm afraid. It's moving towards the American model. And we're not only moving towards the American model in terms of the way these things are investigated and prosecuted, but we are also very much following their model in deferred prosecution agreements, which I will come back to shortly. So the SFO are celebrating 30 years. This is, again, from the SFO website. They're basically saying we've had a fantastic last couple of years, and it's only going to get better. They've got the Barclays trial coming up in January. They've had they're quite buoyed up by their victories. Thank you. Only 5 minutes to go, by the way, so if you're not enjoying this, it's going to be over soon. Now, what are the judges doing about all of this? Well, I mentioned in the 2 minutes remaining, I'm just going to very quickly deal with deferred prosecution agreements. Deferred prosecution agreements have only been out for a couple of years. They're a straight transplant from the American model. And what they do is they basically, it's a deal that you essentially accept guilt, but you don't get a conviction. Instead of the conviction, you give full reparation for your criminal conduct. It's concluded under the supervision of a judge. You have a period where you've got to behave yourself, etc., etc. The good thing is you don't get a conviction. The bad thing is you get everything else apart from the conviction. You get the reputational damage, you get huge fines, and of course this is a picture of Simon Rainey QC's car. It's also yeah, it's also a Rolls Royce. And if you want to look about this, look no further than Rolls Royce. Deferred prosecution agreement last year, £500 million into the Treasury. £13 million of their costs recovered. DOJ $170 million, and the Brazilian authorities $25 million. That was all done under a DPA. Rolls-Royce end up with no conviction, but they end up with massive reputational damage. Of course, you may say, well, they had no choice, because this was quite serious. I mean, that's a quote from the judge, Mr. Justice Leaveson, I think it was, egregious criminality over decades. But this is the way forward, and I think the SFO are aware of it. They're following the American model. The American model is do a deal on a DPA, wrap it all up so there's no trial risk, there's no costs at trial, and get a DPA and get the whole thing done and dusted. That is the way forward. And on that very cheerful note, I'm going to pass over to Annabelle, we're going to finish with a flourish now, I think, with Annabelle. Thank you.
Right, so I'm going to lower the tone even further, I think, by talking about in-house lawyer. So thanks, David, and thanks, Nigel, for the introduction and for inviting me to be on your panel and sharing your learned friends with me. It's been really nice to have learned friends for the evening because we don't get that in-house. So that's been exciting. So I'm going to talk, I wanted to talk about something that would interest all of you. So I thought I would talk about the future, because I think that you may have noticed, but the future seems to have finally caught up with the legal profession. And I think that there may be something potentially quite radical, potentially quite revolutionary just around the corner. So that's what I want to talk about. But before I do, a bit like David, I'm just going to go back to the past. And I just want to sort of first start by remembering those dark days, the pre-digital days. And this was when I was a trainee at Ashurst Morris Crisp, as they were then called. And it may surprise some of you in the audience, some of the younger ones, to know that we didn't use email in those days. We had email. It was sort of an in-house messaging board almost, and it was mainly used by the boys for sharing dirty jokes at that point. What I mainly remember as a trainee was that we did a lot of photocopying. Now, why did we do that? I have no idea, but we did a lot of photocopying, and we did a lot of faxing, because of course most of the communication with the outside world was done by fax. This was mainly done in dark, windowless data rooms. And of course these data rooms were not virtual as people have now. They were real data rooms, and you were locked in them for hours on end. That's what I mainly remember. It wasn't at all like Ally McBeal, as I had hoped, you know. Nobody broke into spontaneous song and dance routines. I did try it, but I was sent back to the data room. And then we did a lot of CPs. I qualified into banking, so we did a lot of CPs. This was kind of, you know, pre-millennium stuff. And it was all done hard copies. I mean, we had spreadsheets, and we had to run up and down through the streets of London, gathering our CPs literally and physically. So I would go to NatWest and I would hand over my notice of assignment, and I would wait for the acknowledgement. I mean, we used to wait around for the acknowledgements of assignment. And you'd be doing this day in, day out, you know, all through the night, because of course it was important to work all through the night so that you could show that you were not a slacker. Because you were either somebody who worked through the night or you were a slacker. And there was really nothing in between. So the CPs, you know, you would find yourself at 4 o'clock in the morning on the steps of Allen and Overy, kind of desperately trying to get your board resolutions signed off before the money could move. And they would say, oh no, you know, you haven't capitalised, guarantor, you know, it has to go back. So you would walk physically back to Appold Street and have to redo it. And this was kind of extremely inefficient, but it was how things were done. And the third important skill, and I should also add that we used to get tombstones in those days. You know, at the end of all of this, you'd be given a tombstone, which again I thought was kind of a slightly ominous sign of things to come in my career. The third important skill that I learned was how to pad out my timesheets to make it look as though I'd done 12 hours of billable work per day. And in fact, what I've been doing, well, you can see I've been doing plenty of stuff. Whether it should have been passed on to the client was, of course, at the discretion of the partner in charge of the matter. But we certainly sat around a lot and did a lot of stuff. Again, whether it was billable or not remains to be seen. Now, I moved in-house. I moved to Goldman Sachs, where I was at least able to get out in daylight hours, usually. And so what I did there was a lot of contracts. So, you know, in-house, you deal with a lot of contracts. So the first type of contracts that I came across were the industry standard. Now, you would hope, wouldn't you, that an industry standard contract would actually be standard. Around that time, they had just published the 2002 ISDA. But nobody actually wanted to use it because human beings being what they are, people were very attached to their 92 ISDA. So we ended up just copying and pasting a load of stuff from the 2002. You'd get your set-off clause, and you would just press Control-C, Control-V, and you were doing that a lot. You got very handy with your copy-paste function, because mostly that's what you were doing. It should have been efficient, but again, it wasn't. And we had lots and lots of committee meetings of ISDA and EFET, and people adding on lots more annexes, lawyers getting together. They couldn't decide about force majeure. The German lawyers, of course, would want to put everything but the kitchen sink into the force majeure clause. The English lawyers preferred not to. So you had all these different side conversations going on. You also had, for emissions, because I did a lot of emissions work, 3 separate industry standards all doing the same job. People couldn't decide whether to use the ISDA, the EFET, or the AITA. So they just had all 3 running in parallel. So you were constantly, again, copying and pasting. So this was really inefficient. Now, what were the traders doing meanwhile? They were massively ahead of us. So we were always a day late and $1 short. You know, they were always trading much, much quicker than we could possibly keep up with them. And the other issue that we had, because of course they were on our backs constantly, where are we? Where are we with the Barclays EFET? You know, how can it be so difficult? And you say, well, here's the reason. Because we're having to go to get all our internal approvals. And we were still using the 90s technology, the Outlook and the Word. So we're writing to credit and compliance, we're writing to tax and treasury and front office and back office and we're writing all these emails separately from the document. And then you've got to kind of scroll through your inbox to try to find the thing where somebody said, can you please align it to RWE? And you go, well, that was an EFET, this is an ISDA, but okay, whatever. So you're constantly copying and pasting, and it's really, really inefficient. Now, at some point, a guy called Yevgeny, who was on the other side of me at Gazprom and then at Morgan Stanley, just realized how inefficient this really was. And he came up with some software. This was a few years ago. And he came to an EFET roundtable meeting that I was at. And he pitched to us an idea that could make this all much more streamlined. And it was a kind of workflow tool. He called it Clause Match. And it was still in its sort of pilot phase. Now, there was a room full of 50 energy lawyers. And we all looked at him and went, oh, no. You know, that won't work. Because I think that it was just too unsettling. He was kind of ahead of himself in working out that actually artificial intelligence would be much more efficient than this kind of 90s technology. But I think that it was a little bit unsettling, and so people didn't quite buy into it. It also wasn't quite ready yet. One of the issues was that it would have required the whole market, really, to go to it, so that your counterparty would have to be on it. But what was good about it was that it would keep everything in one place, so that it's not subject to human error, having to scroll through your inbox and all the inaccuracies that that can bring, and basically just the headache that that is. Now, I'm going to just move on. I'm going to park Yevgeny there, and we're going to come back to him, and we're just going to quickly look at why we go externally. Now, this is always a really difficult sell, isn't it? Because somebody's going to say, well, why can't you do it? Why don't you do it? You're supposed to be the lawyer. So you've always got to get through that hurdle of going, well, actually, we need extra help from our friends and our learned friends in some cases as well. And usually it's because, I mean, it may be that you need extra resources. We are just 3 lawyers at BB Energy and a wonderful paralegal who's here. But we can't do everything. And particularly if somebody decides that they're going to buy a power station, as happened at Vitol, or they're going to invest in an oil refinery, then you just can't, on top of doing your day-to-day and all the contractual stuff, you can't keep up with that project. So you will need extra help there. Sometimes it's specialist knowledge, and particularly regulatory sanctions type of work. Again, we can't keep up with everything that's going on. And of course, every time Donald Trump looks at his phone, we kind of need another update on the regulatory side. And of course, also for case management, we just need that extra help, particularly with litigations. Okay, now my learned friends, I apologise because I'm really lowering the tone now, but I'm going to talk about billing. I'm going to talk about money. And I know that this is a really grubby topic. But it's the first thing that in-house lawyers really need to talk about. And we hate doing it, because it's the elephant in the room, but it's the first thing that we have to talk about when we are instructing external counsel. Because there's a dance going on, because we know we kind of want it for free. We kind of want a favour. And we kind of hope you'll give us it for free, because maybe later there will be some billable work. And we also know that you're going to want to charge us about 6 times more than you should. So somewhere we have to kind of meet each other halfway, and I think that the way to do that is just to flush it out up front. I do think that hourly rates, if I may say so, are a bit of a thing of the past, and that's controversial, but I do think that hourly rates sort of need to be phased out. What lawyers do is they say, well, my hourly rate is this, but we'll discount it. So why don't you just not bother and give us a fixed fee? Or why don't you give us some kind of an estimate? And I think this is the best way to go about it, because of course you don't know how that project will turn out, that transaction, that piece of litigation, mission drift and all that, things happen. But in general, I find that it's an easier sell for me internally to say, okay, they've said it'll be around 40 or 50K, and then we know it's going to be another 20 or something like that. But at least you've kind of got some ballpark figure. Otherwise, it's a terrifying nightmare. While we're on the subject of anachronisms, I do think panels are a bit out of date, I have to say. I know a lot of bigger companies have panels, but apart from this panel, which obviously I'm on, I'm not a massive fan of panels. I think that I've always had to get exemptions from panels to instruct the lawyers I want, because I basically just want the right lawyer for the right job. And often that is Clyde & Co, of course, so yay. And business development really, really quickly, because I know everybody wants to know. I mean, everybody's always cold calling, and at the moment we get a lot of LinkedIn, hi, you don't know me, but, and you kind of go, well, I don't, and why would I instruct you? But, do you know what I mean? So you get this, and I honestly just think the best tip I can give is to do trainings. I think trainings like David's just done, but preferably bring them in-house. And we don't mind that. Okay, I don't mind that. But when people call me up, and it's often the trainee of the partner going, oh, did you know that our partner does LNG? I sort of go, well, so what? We've got a great LNG lawyer, so no, not really. Now, here's one of the problems, and I'm just going to show it. It looks even bigger here, right? Here's a problem that we have as in-house lawyers. We've got a load of documentation that we are drowning in. I mean, we are basically just suffocating under documentation. This stuff is not sexy, it doesn't make any money, and there is always more and more of it, okay? We are drowning in this stuff. Every time the exchanges decide to merge, they will publish another set of rules. Every time there's a new MiFID update, there will be another set of rules. There will always be novations. Banks will be restructuring, companies are restructuring, and they send all their stuff through. Now, what are you going to do about this problem? Because it's not profit-making. You've got all your trading documents as well. Are you going to have a nervous breakdown and stay, till midnight every night? Is that productive? Is that a good use of your time? I mean, I don't think so, but then I would say that, because I just don't believe in that kind of thing. I think there's a couple of solutions, and we're now finally getting to the future. So one way that you can deal with this problem is using the disruptor or challenger law firms, which Nigel's just been reading all about. So this is deploying human resources, but it's deploying them in a different way. So instead of having to have either a new hire, which may prove to be expensive, or having to give it, Clyde & Co. a huge long retainer to do a piece of work, what you can have are these law firms who run a different business model. So it's a more flexible model. So they are able to basically flex resources when it's needed, and then kind of scale them back when they're not needed. And as you can imagine, their overheads are much lower. They often don't have premises or very small premises, and their lawyers are freelance. So they don't have a huge number of salaried employees on their books. Now, why do I believe? I do believe in this, by the way. I do think this is the future. I think it's the immediate future. I believe in it because it's good for clients, but it's also good for lawyers. So it's very good for clients because, in theory, you're getting good quality advice at a much, much more competitive rate. So obviously, what's not to like about that? We're actually currently using Temple Bright. I don't know if anybody here knows them or has used them, but Temple Bright, again, they are quite senior lawyers in their field who previously will have had a city training. So they may have worked at Simmons or at Linklaters, and now they've kind of clubbed together in a sort of learned friend model, and they're really good. So we're currently using a litigator and a construction lawyer. Some of the others, of course, are linked to law firms like Agile, who belong to Eversheds and so on. And they're all a little bit different, but that's what they generally have in common. And the other solution to the problem, which I also believe in, is the use of legal tech or artificial intelligence, which again is not as scary as it sounds. And to go back to Yevgeny, who you remember from a few slides ago, he was working on his model. And over the last 3-4 years, he appears to have really perfected it. He has now sold it, I believe, to Barclays, who are using it for all their compliance work. So that's been a real success story, you know, and it's been described as Google Docs on steroids, because it's kind of like that, and you can keep all your stuff in one place. You can just imagine what a headache it was before, and now people can use that, and I honestly think that is freeing people up to have much more quality of work, and that's why I believe in it, because it was no fun before. So we're getting towards the end now, and I'm going to leave you with a look at the kind of brave new world of legal tech. Now, here's the thing. When Yevgeny came and spoke to us all, people were a little bit threatened. And they were, you know, you could see them just thinking, but why would I bring this in? Because it may potentially put me out of a job. Okay, are we turkeys voting for Christmas? That kind of thing. And I was thinking about this, and I was thinking, you know what, I don't think we are. I think we're more like battery hens voting to go free range. Do you see what I mean? Because I think that it genuinely frees us up to use our intelligence in a better way, and to use our legal training in a more interesting way. And also to use our human skills, paradoxically, as we bring in the robots. Skills like creativity, you know, emotional intelligence, reading between the lines, the spirit and not the letter of the law. And I honestly think that it's very, very liberating. Some of these things, I don't know if you know any of these, but for example, Luminance is a piece of software that can search through contracts for anomalies. So you know how everybody uses Control F, and you're finding things in documents. Luminance, which I think was pioneered by Slaughter and May, can just do that for you, and just isn't that so much nicer? So people can go home and have quality of life. I'm a big believer in quality of life, I really am. And you know, you can look at these at your leisure, because I haven't got time to go through each one of them, but an interesting one to end with is Route 1, which is an app. It's a legal app. So the young people in the audience will be familiar with Tinder. So this is kind of a Tinder for lawyers. Not that I know anything about this, I'm too old. But you know, this is where lawyers can put their profile online, and law firms can, and clients can say what they're looking for, and they can be matched. So you're literally swiping left and swiping right. Okay? So that is sort of the future. So yeah, I'm going to there's one other point I should make, which is that, of course, code of conduct. You know, that is something that a robot cannot do. You try asking Alexa, because I did say to my little robot Alexa, I said, Alexa, have you got a moral compass? And she sort of said very dismissively, I'm sorry, I can't help you with that one. So that's my sort of final tip. 3 takeaways from today. Billing, keep it transparent. Disrupt to law firms, give them a go, what have you got to lose? And artificial intelligence, I really think it's the future, because it can give us quality of life as well as quality of work. And what's not to like about that? Thank you.
Ladies and gentlemen, that brings to the end our 4 presentations. We do have some time for...
Well, it was a pretty bold step on their part, and they applied for summary judgment on the basis that we would have no defence to a legal argument that if we placed all our eggs in one basket with Samarco, we should have placed some alternative eggs or arranged an alternative basket with Vale. And they said, as a matter of law, we simply didn't have a defence. The judge found that very surprising. They had a very hard uphill battle. They were also, I think, going to argue other points about the Samarco dam burst, but that also came out. So it was meant to be put purely on a legal basis, and I think it was very, very brave of them. But it's certainly given us a very good opportunity to see what their arguments are, and even to talk about them. Whether they're interesting or not is a matter for you, not me.
Do you know what? I think that, yes, it definitely is the gig economy. There's no doubt about it. In fact, Vario, one of those, actively encourages its lawyers to have a side thing. So in America, they call it a side hustle. So basically, either a second job or a secondary interest. There is a danger of a race to the bottom, but I personally think that just like Uber, it keeps things more competitive. So I'm not so sure, actually, that there's a danger. I think that you're right that it definitely will turn into something a bit like that. But again, I think this is an intermediary phase. I don't think this is the end phase. Richard Susskind, who wrote a book called Tomorrow's Lawyers, and that's where I would refer you to, kind of predicts that the law firm model in the future, and I'm talking specifically about law firms now, that there will be fewer lawyers and more technicians, and that there will just generally be fewer sort of junior lawyers, more technology, and sort of a number of experts who will then interpret that data. So I think that's where it's going. I think that we'll get through this phase at some point.
The liability for perpetual monitoring is something imposed by statute on the operator. And so you may have operators entering into agreements with other companies, JVs or otherwise, to carry out the monitoring on their behalf. But what you won't be able to have is a thorough, I'll get rid of that, thank you, unless the Secretary of State makes an order under, I think it's Section 29 of the 1998 Act, allowing the transfer or the withdrawal of the liability. So yes, you could have disputes, but it won't be quite what you envisage, which is the liability being firmly anchored with a company, which then goes bust. And you can have very interesting and difficult problems, and there are interesting and difficult problems arising with the administration and liquidation of companies in the North Sea, and what happens to their liabilities under the Act. And that's one of the reasons the Secretary of State can go back in time to previous operators or even future ones. But I don't foresee the particular concatenation that you raise causing particular difficulty.
So I hope you'll now join with me in thanking all our speakers, each of whom has provided a valuable insight into topics that are current in the market, and each of whom has also demonstrated with clarity in the thoughtfulness of their presentations the truth of the old adage that it takes time to reduce complex issues to concise and simple propositions. So thank you very much to all our speakers. Can I also invite you to thank all those people who have been involved in the organisation of tonight's event, both from Clyde & Co and from Quadrant Chambers. So again, thank you very much. And with that, it just remains for me to thank you for your attention and to invite you to join us for a drink and the opportunity for further conversation. Thank you very much.